Not the suitable property is the not the self-acquired property of not the plaintiff. Not who relationship is. Not the plaintiff is the not the mother of respondent number 2.
Plaintiff is the mother.
Mother of
Defendant is?
First respondent is the not the wife of respondent number 2.
Plaintiff is the mother-in-law, my lords.
Plaintiff is the
Mother-in-law of the defendant number 1.
Defendant number 1 is the daughter-in-law.
Daughter-in-law.
Yes.
The respondent number 1 filed not of the application seeking to not of the provide access to the common areas.
Access to the
common areas. Plus, we have filed an objection. Suit is for the lot of the 2018. Till 2018 to 24, there was no impediment for her to why I am bringing to the knowledge of this honorable court. Either the respondent number 1 or the respondent number 2 has no right over the self-acquired property of the plaintiff.
It will be decided.
What is scheduled property is not a 3-floor building, in one of the second floor. She trespassed. First respondent trespassed into the property and is sitting over the property.
So she is in occupation of the building.
Yes.
You are not occupying
Yes.
it. You are not there.
Yes.
You are not using it.
Yes.
So if she uses the common area,
But there was an interim order.
that it is at the fag end of the stage. What is the difficulty to the mother?
Difficulty is this, my lord.
Is it that she wants to harass her in that way?
No. Son of the respondent number 1, removing the things, my lord, and the damaged the property, glass panes and the doors and all. I have produced all those, including CCTV cameras. His photo could be seen from that.
Accept all your contentions that the property belongs to you. It's a self-acquired property.
Yes.
Defendant has no right to enter into the property.
Yes, ma'am.
You have filed a suit seeking recovery of your possession. Now, till pending, when the suit is pending,
But interim order was there to maintain status quo.
status quo is
Status quo, then again, considering this application in the fag end of the stage, in the final argument. In 1 or 2 days, the argument will be over. At this stage, considering and asking him to remove the locks and all, the sump locks and all. At this stage, if 2 days, the argument is finished, everything will be finished. At this
The one that is the respondent here in my lords is the daughter-in-law of the house, and the suit shall property is a matrimonial home. And hence, the Honorable Supreme Court of the year 2021, she can claim a right to reside as per Section 17 of the Protection of Women from Domestic Violence Act. Trial court where they have disrupted the electricity, water connection, and I had to live in dark also, and I've approached the BESCOM authorities seeking that please restore the electricity connection because I'm not able to lead day-to-day life. There has been water disruption, and I have gone out from second floor and to fetch even basic for cooking also and drinking also, water purposes also. I had to go out and get the water, my lords. But since now I'm not able to do that because of my health issues, as my with my proceeding age also, I'm in my 40s now, and I'm not able. Order was passed on 3/8/2024, directing the plaintiff number 1 to open the locks within 3 days, which they have not complied with, and hence I was constrained to file a contempt application. At this stage, I filed an application to break open the locks, especially of the roof, because the water in the kitchen has decreased substantially, the water flow, to get the repair done, my lords. All the water ducts are either there in the utility area in the basement or on the terrace, for which I have no access. If the water stops tomorrow, my lords, I have absolutely no access to the basic necessity for survival, that is water, my lords.
The appellant is not the age about 84 years. The suit is for the mandatory injunction to quit and deliver the vacant position of the Schedule B property. Against the respondent number 1 and 2, who are the husband and wife, or wife and husband. The suitable property is the self-acquired property of the plaintiff, who inherited the property from her mother.
Now, what is the relationship between the plaintiff and the defendant?
Relationship is the plaintiff is the mother of respondent number 2.
Plaintiff is the mother.
Mother of
Defendant is?
First respondent is the wife of respondent number 2.
Plaintiff is the mother-in-law, my lords.
Plaintiff is the
Mother-in-law of the defendant number 1.
Defendant number 1 is the daughter-in-law.
Daughter-in-law.
Yes.
Not,
What is the application that you have filed?
the application they had filed before I could come. This petition is not the pending since 2018. OS is filed on 17/11/2018. Lord, on 29/5/2024 itself, Lord, the matter was posted for not the final argument.
What is the date?
29/5/2024. Matter was not the posted for final arguments, not after not the evidence. And not the on not the application was filed on not the application was filed on 3/7/2024. Before notice I could say notice on not the there was a interim order of not the status quo. Notice that is on. But the interim order of status quo was not the order by the not the trial court not earlier to not the 2019. I'll give the
What
date.
is the interim order?
Not interim order maintain not status quo between the parties. Not such being the fact, not on 3/7/2024, not
Yes.
not the respondent number 1 filed not the application seeking to not the provide access to the common areas.
Access to the common.
Access to the common areas. Plus, we have filed an objection. Suit is for the lot of the 2018. Lot till 2018 to 24, lot there was no lot of the impediment for her to lot of the this thing and all. Lot of the using the things thing and only to lot of the drag on the matter and to harass this lot of the appellant herein.
Please come to the. Please come to the application.
Before I come, I will take my lords to the one moment. Not of the, I will take not of the, this is the not of the self-acquired property of the plaintiff. Not of, I will show not of the sale deed not for a moment.
No, before that.
I will come, lords. I will come, lords. That not of the page number 55 is the not of the sale deed. Not of this is dated 35/1962. Not of the plaintiff's not of the appellant's mother purchased this property in the year 1962. Lords. That not page number 55. 35/1962, not she purchased, not plaintiff's mother purchased, not she plaintiff's mother died in the year 1988.
Yes.
Not subsequently after the death, not she inherited this property.
Yes.
Not my wife, not I am bringing to the knowledge of this honorable court. Not either the not the respondent number 1 or the respondent number 2 has no right over the not the self-acquired property of not the plaintiff.
It will be decided.
That not I will come to that. Yes. Even in this matter, not the IA also not.
Please come to the IA. What is that they have filed? We will see that.
Yes, ma'am.
IA.
Application is not page number 25. Page number.
What is the suit schedule?
Page number
property?
50. Not.
What
Suit
is
schedule property is not a 3-floor building. Not in one of the not of the second floor. See not trespass. First respondent trespassed into the property and not is sitting over the property.
So she is staying in the first floor.
Second floor.
Second floor.
Second
Where is the plaintiff staying?
Not
Plaintiff.
Plaintiff is not, it is suit schedule property belongs to the plaintiff, not due to harassment.
Belongs to
Yes.
him. Where?
Yes.
In which floor she is residing?
Not I will come before I could come to those things.
Make a submission.
One
Plaintiff
moment,
is
one
not
minute.
residing in the suitable property.
Yes, I do agree, Lords, because due to harassment caused by the Lords, the respondent number 1, Lords, he could not able to stay there. Lords, now he is staying with Lords, her son, Doctor one, Lords, the Chandramouli. Lords, he is there. But the fact is this, Lords, in the year 2000,
Yes, sir.
Lords, the impugned order is Lords, the
For the impugned order,
application.
please come to page number 50.
50, Lords.
Yes.
Page number 50, Lords. 50 is the Lords, the application what they have
We'll
filed.
look at it. What is that she's
Yes.
asked?
Not for the reason shown to in the accompanying affidavit, defendant number 1 prays that honorable court may be pleased to direct the plaintiff to allow her access to the common areas in the suit schedule property by opening the locks of the common areas, common utilities as listed below in the interest of justice and equity. Not she has mentioned not there are 4 not the roof, terrace building stated so and so, utility areas, basement, some from so and so. Not we have immediately we have filed the objection. Not this application
There
is
is no, there is just, this is the petition. What is the very, there is no affidavit to this?
17/11/2018 is the lot of they have filed the OS. 6/1/2019 is the lot of the order of status quo by the lot of the both the parties. Lot in the year 2023, lot we have approached lot of this honorable court, wherein lot of this honorable court directed to lot of the speed up the proceeding and not the finished up within 6 months, not in the year 2023.
No, she is in occupation of the building.
Yes,
You are
ma'am.
not occupying,
Yes,
you are not
yes,
there,
yes.
you are not using it.
Yes.
So if she uses the common area,
Lords,
what is your
Lord, there was an
difficulty?
interim order earlier on 6/1/2019 till Lords, from that day to up to Lord 2024, there was no impediment for her to Lord the all these things. Now only in the fag end of the stage, Lord. Now the
Let's think that it is at the fag end of the stage. What is the difficulty to the mother?
difficulty is this, Lord.
Is it that she wants to harass her in that way?
No, no, no. Difficulty is this, Lords. I may take Lords to the page number 86, Lords, for a moment. What Lord they are doing in the Lord of the suit schedule property. Lord, the son of the Lord of the respondent number 1, removing the things, Lord, and Lord of the damaged the property, Lord, glass panes and Lord of the doors and all, Lord, I have produced all those, including CCTV cameras, Lord, his photo could be seen from that. And Lord, if Lordship opened those things, Lord, then Lord, she will remove.
Only these people, everybody is having an access, other people.
No, Lord, first of all, Lord, she is a trespasser. Lord, this is self-acquired property of mother-in-law. Neither Lord the son nor Lord his wife has Lord the right to Lord over the property. Lord, this property is Lord in between, dispute is in between the Lord of the respondent number 1 and 2 is Lord since from December 2007. December 2007, Lord, she left the Lord the company of Lord the respondent number 2, and Lord she residing elsewhere. And Lord, this property is not constructed in the year 2014. Lord, 2014, Lord, she obtained the plan. 2015, she started construction. She Lord completed the construction, Lord, in the year 2018. Lord, before housewarming ceremony, sir, Lord, she suddenly, Lord, they entered into the Lord the second floor of the house and squat over there. And subsequently, Lord, she filed Lord the suit seeking Lord the mandatory injunction to Lord the
No,
quit and
let's
vacate.
accept all your contentions that the property belongs to you. It's a self-acquired property.
Yes,
Defendant has no right to
Yes.
enter into the property.
yes, Lord.
You have filed a suit seeking recovery of
Yes,
your possession.
Yes.
Now, till pending, when the suit is pending,
But interim order was there to maintain status quo.
status quo is what?
Status quo, Lord, then again, Lord, considering this application in the fag end of the stage, Lord, in the Lord, the final argument, in 1 or 2 days, Lord, the argument will be over. Lord, at this stage, Lord, considering and Lord is asking him to Lord, the remove the locks and all, Lord, the sump locks and all. Lord, so this at this stage, Lord, if Lord, 2 days, Lord, the argument is finished, Lord, everything will be finished. At this stage, Lord, the order, passing the order to Lord, the provide them access. Lord, if the access is,
Please come to the impugned order.
Lord,
Yes.
Lord, after this, Lord, allowing this application, she filed not 2 applications. One is contempt and one other is not permitted to break open the locks and all. Not subsequent of not this order. Not the impugned order is not the only page number, not the para number 12, not page number 20. Not wherein not the trial court, not the may I read not the trial court mentioned.
I've read details.
Yes,
of it.
this is not the when the matter is not of the in the fag end of the stage and not of the allowing this application, not of the since 2018 to not 24, there was no impediment for not for anything for her. And only not of the in the year 2024 filing this application and not of the allowing this application and not of the and based on that not she has filed not 2 applications. One is contempt and one is not. Not this is the situation. Not my submission to my lord is not there was a not the interim order of status quo since not 2019. And moreover, not this honorable court in MFA, not they directed the not of the trial court to not of the pass the not of this order within not of the 6 months. Such being the fact, not this taking not of this application and not of the passing this order and not of the without not seeing the earlier order that not of the order of status quo and not permitting her permitting the not of the respondent number 1 to use the not of the that is only not in the ground floor toilet. And it is meant for lot of the plaintiff's use, not for lot. She is only lot of the second floor, even though she is a trespasser, not a lot of the tenant, not a lot of the leaseholder. Nothing is there. Even lot if she claims that lot is a shared household, not she can't be claimed as a shared household because not this property is not she left the company of not the second respondent in the year 2007. This property is constructed in the year, started constructed in the year 2014, completed in the year 2018. My lord, April 2018, my lord, she trespassed into the property. And even thereafter, my lord, filed the suit. And my lord, after filing the suit till 2024, there was no impediment. And my lord, the filing of this application, my lord, the allowing, my lord, at this stage. And my lord, the which, my lord, that not only, my lord, I have produced the photographs, my lord, showing that, my lord, how the son of, my lord, the respondent number 1 damaged the, my lord, door and, my lord, the window panes. And my lord, the taking the, my lord, the taking away the things from that, my lord, the building and all. It could be seen from the, not the photographs of the CCTV. Such being the, not the case, not if allowed her to not use the, not the common areas, not it will cause, not the irreparable, not the hardship to the, not the appellant herein. Because, not the, if my lords, I opened the, not the sump and all, she may pollute the water and all, and not the that ground floor, not the toilets are situated. Not she is residing in, not the second floor. I don't know, not what purpose, not she needs those things, because not it is my property, not it is not constructed for my purpose, and not even terrace portion also not for what purpose, not I don't want to shame, not the he is doing not the parties and all, because of that not she wanted not that property in the terrace portion.
Yes.
My lords, the defendant number 1, that is the respondent herein, my lords, is the daughter-in-law of the house, and the suit shall property is a matrimonial home. And hence, she has claimed in a written statement, the suit is for mandatory injunction filed by the plaintiff seeking for eviction of the defendant number 1. The defendant number 1 has taken a contention that since it is a matrimonial home and a shared household, and as per the division bench judgment of the Honorable Supreme Court of the year 2021, she can claim a right to reside as per section 17 of the Protection of Women from Domestic Violence Act. The Honorable Supreme Court says, only after leading evidence and only on proof that there is domestic violence and domestic relationship, and it is proved that a shared household, she has a right to reside, and that right has to be decided by the Honorable Civil Court. But meanwhile,
No, right from 2018, you're not using that common areas. So why did you not come up with an application earlier?
Since 2018, they admit I am in possession of the future property or the written statement scheduled property. My lords, there are various complaints filed which is marked even before the Honorable Trial Court, where they have disrupted the electricity, water connection, and I had to live in dark also, and I've approached the BESCOM authorities seeking that please restore the electricity connection because I'm not able to lead day-to-day life. There has been water disruption, and I have gone out from second floor and to fetch even basic for cooking also and drinking also, water purposes also. I had to go out and get the water, my lords. But since now I'm not able to do that because of my health issues, as my with my proceeding age also, I'm in my 40s now, and I'm not able to do that or undergo such sort of effort to get water or the basic necessity.
Where did you say all that? That what was the reason for moving an application in 2024, when you're staying in the house from the last 6 years?
Well, those complaints have already been marked.
For this application, there should be a reason when you're moving it in 2024 in a pending suit, being a defendant in the suit. You should say why it is.
I have stated that there has been disruptions, and hence to access
To have
for
the
it-
application, where did
for
you read it?
It's not there in my file also, my lords.
What have you passed on?
My lords, that was the contempt application because this order was passed on 3/8/2024, directing the plaintiff number 1 to open the locks within 3 days, which they have not complied with, and hence I was constrained to file a contempt application. Since now there is no water, I mean the water is decreasing day by day. I mean the flow of the water in the kitchen.
So it's not you alone staying. There are 3 floors. You stay in one
There's
floor.
no one else staying in the whole building except me and my minor son. My lords. There's no one else in the building.
No, there are
No other occupants.
ground floor and first floor or
Entire thing is vacant. Entire
it's not
thing.
given. It is not rented out.
I am staying and maintaining the entire property as cleaning and repairs and everything. That is the reason, my lords.
Is it correct that first the ground floor and the
Lords,
other floor is not occupied
Lords,
by
I
anybody?
am having photographs. Lords, nobody can stay there. Lords, such a Lord, the horrible lady she is. Lord, she is aged about 84 years, appellant. And Lord, after Lord, she filed Lord in the year 2007 498 against all the family members. My lords, all the family members also, my lords, left this person also, my lord, the respondent number 2. He is residing elsewhere. And my lord, because my lord, the 498A she has filed, my lord, in 498 she herself stated that, my lord, since from 2007 up to 2018, my lord, she was in different address. I have produced all those documents before this one. Not this not aged about 84 years, this lady. Not not if she go near that, not if she push it, not she will fall down. That lady, that is the position of her.
Please no.
My lords, my right to possession includes enjoying of whether it is a rightful possession or wrongful
No,
possession.
there is
Is
no,
yet to be
no,
decided.
no, there is not. No argument on that is required. It is settled that you have to enjoy it. The only query of the court is, why did you not do it from 18 to 24? That's the only query of the.
Well, lords, I went to the extent of going out and getting water. I mean, that is the trouble I've been through. But finally, I'm not able to do it due to my health reasons at this stage. And common
Wait, but
amenities
the
becomes a necessity, my lords, to any survival.
The
my lords.
orders passed.
I may make a submission, my lords. Now, at this stage, I filed an application to break open the locks, especially of the roof, because the water in the kitchen has decreased substantially, the water flow. To get the repair done, my lords, all the water ducts are either there in the utility area in the basement or on the terrace, for which I have no access. If the water stops tomorrow, my lords, I have absolutely no access to the basic necessity for survival, that is water, my lords.
As rightly contended by the land council for the appellant, this application is filed at the fag end of the trial. It's when the suit is of the year 2018. That application is filed in the year 2024. Just because the application is filed at the fag end of the trial, that itself cannot be a ground for the court to dismiss the application. As long as the defendant is staying in the said premises, she has to have the access to all the common areas and to all the utilities. Now, by granting any of the, by allowing these applications, no prejudice would be caused to the plaintiff, as the plaintiff is not residing in the building. When once the court comes to the conclusion that the defendant is not entitled, and the other steps would be followed. But as long as she is in occupation of the property exclusively in the second floor, she needs to have the access to all the common amenities. In view of the disputes between the mother-in-law and the daughter-in-law, she cannot log it cannot be said that by granting access to the basic, to the common areas, that a prejudice is caused to the plaintiff. This court is not able to appreciate the contentions raised on behalf of the plaintiff, appellant plaintiff, and in the considered opinion of this court, the trial court had rightly allowed the applications, and this court finds no reasons to interfere. Accordingly, appeal is dismissed.